Hello? Hello? That's how I call my kids. Going back to curves. Ooh, you already are on easements. Easements is the next page.
Do you want me to back up?
Back up one to curves, description 2. Okay, concentric, common radius points. Radius, if senior to the other elements, call it first. We went over this, you were right. And the concavity of the curve is from the MOC to the radius point, and I didn't mean to make a scientific exercise on which direction you call. I'd like it to be nearly close. In other words, if it should be northeasterly, it's going in a more northeasterly direction than northerly or easterly. But at least so when we're sketching this out or drafting the legal description, the radius point isn't in the wrong quad or in the wrong quarter. Okay, now we go to easements. This is amazing we got this far. Do we have a time warp or something? Okay, an easement is appurtenant when it is attached to and for the benefit of the dominant, the grantee, tenement. In English, if I buy a lot and in order to get to the public road, I'm granted an easement over the grantor's land, that easement becomes appurtenant to and attached to my legal description. Not to me. It's not an easement in gross. It's not an easement to me. It's an easement to the land I bought. Is that clear? Easement in gross is personal. This is not an easement in gross. It's an easement appurtenant. And if that easement is never mentioned again in the selling and selling and selling of that lot that I bought, the easement never goes away. And the easement can only be extinguished if I, or the current dominant tenant. Does everybody understand dominant and servient tenements? I guess I should define that. The dominant tenement is the one you give the easement to. They're dominant. The servient tenement, wait a minute. The servient tenement is the grantor. That's the one who provides the service. The dominant tenement dominates. That's the one who owns the easement right. Not the land, but the easement right. They're dominant. So an attached easement or an appurtenant easement is attached to the land, and the dominant tenement is the one who the easement serves. If I bought the lot and that is my easement to get to the road, it was given to me, then I'm the dominant tenement, and the only way that easement can be extinguished is if I quitclaim it, or my successor in interest on that property quitclaims it. There you go. Yes, if I purchase the lot over which the easement exists, then the easement would be extinguished by merger. The servient tenement, therefore, is the grantor, and the land burdened with the servitude, the land encumbered by the easement. An easement is a right of use over the property of another. Now, an easement is a very, how do I want to say this? It is a very dominant thing. If you have an easement over my land, I obviously cannot put a garage there. You have a right to be able to use that easement for your use. If Southern California Edison has an easement over the land, I can't preclude their use of the underground or overhead utilities that easement is for, including their access, their equipment, or whatever else. Now let's go to an easement in gross. An easement in gross is very unusual. An easement in gross, to make it very simple, is if you own property in Montana and you want to allow me to come and hunt during deer season or elk season. I'd like to come and hunt on your property. You give me an easement in gross to hunt over a certain portion of your ranch. That might not be called an easement in gross, but it is. And the easement would not be transferable by me and would die with me. Now let's go to something that is not clear. the easement to LA Water and Power. LA Water and Power is an entity. The easement is to them. What happens if LA Water and Power sells a huge portion of their interest to Southern California Edison? Does Edison have the easement? Well, legally, is it an easement in gross or is it an appurtenant easement? Well, LA Water and Power doesn't own any of those lots. So how can it be an easement appurtenant? It's not appurtenant to anything. So it gets to be really cloudy. And I mentioned, I think at lunch, that a friend of mine was a surveyor for LA Water and Power. Don Bender is his name. He now resides in Wyoming. And he went to the San Fernando Valley School of Law and got a degree in law and then passed the bar exam. So he started addressing questions like this as a lawyer to his higher-ups, to the people running the Bureau of whatever they call it, Water and Power, the engineers. And he ended up being asked to retire. Now, he was eligible to retire, but they wanted him as a senior supervisor for survey, not as a lawyer. But he was trying to introduce them to their liability in some of their work. He said that when they would clean the, I guess they would be part of the equipment that was on the telephone poles, the insulators and such, they cleaned them with just plain water. Well, they would park out in the street and they had a relatively powerful hose on the truck and they would just squirt right over the houses and clean the insulators. And he was saying, you can't do that. You have no right to do this. You don't have an easement to squirt over this. They come home and wonder why the side of their house is wet. And, of course, Water and Power said, well, you know, they go along the golden rule. They got the power. They make the rules. So that's an easement in gross. A fee is an estate in land. I don't know anybody who has fee simple absolute. Now, somebody somewhere that got a patent from the U.S. government in government land surveying, if they own that patent, they may have a title called fee simple absolute. That means they own title to that land complete. There is no zoning, there is no easements of any kind, there is nothing that precludes them from using that property in any way, shape, or form they see fit. Now, there is no such thing. I own a home in Santa Clarita. I'm not allowed to turn my home into my survey office. If I do, I certainly can't advertise. I can't put a big sign on the corner. Pulaski Land Surveying, that would violate zoning laws. I'm not allowed to sell my home brew out of the garage. Zoning laws preclude me from running a liquor store, et cetera, et cetera. So I have a fee title subject to all of the encumbrances by that tract of land and the zoning ordinances of the city that I live in. Ingress and egress is interesting. Ingress and egress is the right to go in upon and return and get out of a portion of land. It's access. And I don't know that if you said, you drafted an easement and you said this is an easement for access, if it somehow legally would not be interpreted as ingress and egress. But when we draft an easement for ingress and egress, we say what it's for. If it's going to be a public road, we say for all purposes of a public road. Yes?
Have you ever had to deal with overburdening somebody?
Yes. Yes. We did a parcel map for a large piece of property that got access to the large piece of property by an easement over 2 other pieces of land. And when they did a parcel map, now that one lot became 4. And it would be like here's my survey, and here is an easement out to the road over this land here. Well, when this owner acquired the easement across A's land and B's land, it was 1 lot. He didn't acquire an easement for the purpose of 4 residences. He acquired the easement for the purpose of 1 ownership. So what Warren Bassard, the title officer, advised And this is a different day in working with title companies than it is today. Back then, it was just different. Title officers were extremely educated in this stuff. They knew what they were insuring or assuring, and they would work hand in hand with the surveyor. Anyway, Warren Bessard told me that that easement is now overburdened. And so we simply drafted a new easement and had it granted to serve all 4 of those parcels. Yes.
Would that same thing be very true of a prescriptive easement on a piece of property when somebody divides a property that had prescriptive use into 2 parcels and builds houses on them, yeah, definitely overburdening the prescriptive easement.
Well, a prescriptive easement, in my understanding, is an easement that can ripen into a title. It's evidence of an easement that may be there. The easement itself can only exist when granted by the court, or obviously granted by the servient tenement. But if there's a prescriptive right, if you're using a road, and you're using this road to get to your 20 acres, and you decide that you're going to make 5, well, let's don't do a tract map, you're going to make 4 parcels. So you do a subdivision and you continue to use the road. And there is no easement. It's just use. So you have a prescriptive right. Now the person who owns that land, who was a absentee landlord, so to speak, lived in Montana, comes out and wants to do something with the property, sees your road, hires someone here to do a survey, and they show the road and they make a statement that the road is being used to serve these other properties. Well, the absentee landlord may come in and object. Wait a minute, I'm going to gate this off. And this happens all the time. So you put up a gate and deny me access to my 4 lots. And so now we go to court. And I have to prove to the court, the judge or the jury, normally just the judge, and I've got to prove to them that, 1, this is an easement appurtenant because it's been in use for years, and I have to show that to them. And it's also an easement by necessity, because if you gate that off, I'm landlocked. I can't get anywhere. Now, landlocked is an easement of necessity is a peculiar animal. It's hard to get an easement by necessity just because you want one. Yes?
I have a question about gross easement. Can it be terminated by the grantor since it's a median easement?
An easement in gross will last until the easement is... An easement in gross is not a license. A license can be terminated by the grantor. An easement in gross cannot be terminated, but will be terminated if the individual or entity that owns the easement in gross is no longer there, passes away. Like I'm hunting on your land in Montana, and all of a sudden I decide I'm getting too feeble, I can't hunt anymore, and I invite my 3 sons to go up there and hunt on your land. No. I have the easement, not them. And then I kick the bucket, you're out. There is no easement. Yes?
In the case of development, if you want to develop that you've given an easement in gross to, can you develop and extinguish that, or does that remain? And that's exclusively for you to hunt on, and I can't do any development or anything on the land. Wow.
Pretty much.
Yeah.
Pretty much. I want to tell you guys something. Don Bender, I mentioned him, right? Water and Power. Don Bender told the whole class. He did a class like this on easements. 8-hour day on easements from a lawyer's perspective. And he said something that we can't always do, rarely do. He said, stop writing easements. Start writing licenses. Give the grantor some right. When the grantor grants an easement, the grantor is a slave to that use forever. Or until the easement have to be extinguished by ownership. Yes?
Back to the overburdening of an easement. If the original easement had been given for just the 1 lot, like you had said, and now they're going to develop, does the grantor have any rights to say, no, that's too much traffic, I don't want that in here now?
Yep. Yes.
So there could be a...
Yeah, the title company was concerned relative to their liability that we would have a parcel map recorded and occupied, and someday down the road, one of those 2, A or B, would say, hey, wait a minute. I didn't agree to all this traffic. And now extinguish the access. Yeah, they were looking at their liability and really helping my client out by asking us to fix this.
Could they extinguish the access? They couldn't extinguish access to all four. They would always have to allow access to one lot, because that's what they first allowed, right?
Right. And at 3 o'clock, it's access to lot 1. At 3:15, it's access.
Right.
I don't know how they do it. That could be a quagmire. Yes, money. Okay, I've got several pages, a few pages on notes. Always have a co-worker, whoever it is, read your easement. My son Tony is not a licensed land surveyor, but he's drafted 98% of the documents that have been drafted with my signature over the last 10 years. I stopped drafting easements, and the staff started drafting the easements a long time ago. I read the easements and redline them up the way I want them so I can sign and seal them. And I don't have the employees ever sign a map or an easement. Do you know why? I'm not liable, they're liable. I'm looping them into the liability of, like Debbie. Debbie is an employee of Jerry and me, Debbie Naves, and she has signed 2 maps. I mean, you can't be a land surveyor all your life and not sign a map. But we don't want her to assume the liability of a project. If it goes south and there's a lawsuit, they're going to be coming to Debbie. They're not going to sue me, they're going to sue Debbie. Or bring Debbie into a lawsuit to explain what she did, whether she's working for us or working somewhere else. Obviously, Debbie is quite a bit younger than I am, so she's going to outlive our company unless she buys it. And so when she becomes a principal, then she can assume that liability if she wants to. Now, my son Tom is a licensed land surveyor, and he works for Somas. I don't know how many employees Somas has at this time, but they're humongous. They're in several states, and I asked Tom if he signs maps. He signs maps in the Santa Clarita office if and only if Rob Olson is not available to sign the map. But I said, well, how in the world, why would you take on that liability? He said, because I have an errors and omissions insurance policy on me. So that I've always wondered, how do they handle that for large companies? And they they have an error emissions insurance policy for the company, then they have an error and emissions insurance policy specifically for every engineer and surveyor who signed maps and plans. I thought that's pretty cool. But that doesn't take away the fact that if Tom signed a map and there was a lawsuit, that he would be freely donating his time to untie the knots of the lawsuit. He still is going to be on the hot seat, but he's going to have a title insurance company there to, if he's not incompetent, doesn't show incompetence, they will be able to protect him. There are a list of do's and don'ts in the appendix of Waddles. I'm going to tell you something that, oh Lord, I've never done. When you draft a legal description, always refer to the appendix in Waddles about the do's and don'ts. I would say that I disagree with Waddles on something. Point number 322, I don't think he's right. Something simple. I want to say adjoining, he likes coincident with, I think. So I like adjoining. But I would rather agree with Waddles 100% than very, very much off that path, because that book can be cited in court. Waddles and Brown, more so Brown than Waddles, have cited court cases for their principles. And so the court will look to that. Your work as a land surveyor is looked upon by you in the land surveyor community in one way. It's looked upon differently in a court of law. Yet if you didn't follow one of the principles in Brown, like Brown says, maybe it's not Brown, it's said in law, to prorate is a means of last resort. I think that's what I hear. That's probably a quote. Well, when you're in a tract and you locate the frontage street and the side streets and you want to set the front corners and it's got 2/10 overage or shortage, you're probably going to end up prorating. So what did the law mean by prorate as a means of last resort. You're going to have to explain that to the court, that these are simultaneous conveyances. It was intended that all of these lots get their proportionate share of the whole. But you've got to explain it to them, because the court's going to think that that rule of law, proportion is a means of last resort, and you did it as a first resort? Why didn't you hold to the hedges as to where the lot lines go? Or 5 feet off the sides of the garage? Well, then you're going to have to explain to the court that that garage, I cannot prove you that that garage was, the foundation was set 5 feet off the original monuments of the tract for that lot. I can't prove that. So why would I hold the garage? I mean, you've got to be prepared to prove when you don't follow these rules of law as to why you didn't. It doesn't mean that you did wrong. It means that you have to be able to stand up under the law. Stand up under the law doesn't mean that you'll never get tickled by a subpoena. It means that you'll be able to explain yourself sufficiently that your lawyer, the one that works for your E&O company, will be able to defend you as a competent land surveyor. Have your client's attorney review your description and draft the vesting language. The vesting language is the conveyance. Now, rarely does our client's attorney ever draft the vesting language. All the time with the Valencia Water District, we just do Exhibit A and a sketch. Then the attorney for the Valencia Water District does the cover sheet or the vesting sheet all the time. But all the time, I ask the client to run the legal description by their attorney. And if they look, I said, do you have an attorney to run this by? Are you going to do this? Would you like me to draft the vesting sheet and you take it to your attorney? And if they look at me, I say, okay, I'll do that. I'll draft the vesting sheet, then I will give you a transmittal saying that the legal description, including the vesting sheet or the cover sheet, is attached. Please have your attorney review the vesting. Now, I think I may be off the hook. But I don't know anything about legal hooks. They go places where I don't understand. So I think I'm off the hook because I instructed in writing my client to have the attorney review the vesting sheet. And that's something we try to do and don't do often enough by a huge amount, is to have notes in our file or in the CAD file somewhere explaining why we did what we did and how we did it. But as far as contracts, I got contracts down to where I'm reasonably pleased that when the client signs the contract, what we're going to do fits their need and properly describes what I have to do under the law to meet their need. Ask your client's title company to review your work for insurability. The only time in recent history when we did that is when Jerry was asked to modify his legal description by a city engineer. And he thought that legal description as modified by the city engineer was going to be a problem. So he gave a copy to the title company, and the title company just wrote him a note. This legal description would negate insurance. Now, this was private property. Maybe if it was city land, they wouldn't care. But this is a legal description for a private road. And so Jerry just showed that to the city engineer. These people deserve to be able to get title insurance on their strip that encumbers their property. And you, by your legal description, they couldn't do it. So that city engineer allowed Jerry to draft it properly. Notes number 2. Oh, my Lord, we're at the end. Always sign and seal your legal descriptions. It's the law that we have to do that. In fact, anything that I give to a client, to the city, that took land surveying expertise to create, any notes that I do, I sign and seal. But then I had the question one time that thought was interesting. Do you sign and seal the contracts? Oh. Why not? I don't know. Nobody does. Well, yes, they do. Why don't you attach your seal? It's obviously signed, because I've never attached my seal. And it's not a survey report. Maybe that's the difference. They said, well, Exhibit A says exactly what you're going to survey, and it does cite the LS Act or the zoning ordinances of the community that we're in, why isn't that surveying? So there's a reasonable argument that I should be sealing the contract. I don't, but so far I haven't been in trouble for that. A legal description is different than your parcel map or your tract map or even your record of survey in most areas that we work in. Tract map, parcel map, for sure, and a record of survey usually is going to be reviewed by a competent, maybe not according to your opinion, but by a competent reviewer. And they're going to ask you questions. And since in the case of, in case of all three of those maps, the county surveyor or the city engineer have to sign. Now it's becoming more and more troublesome for city engineers to sign that the map is technically correct because they can't. Most of the surveyors, engineers that are pre-82 engineers are long since retired. My partner is a pre-82 engineer, but he's 73. So most of those city engineers are post-82 and they cannot sign. So the county surveyor is the one that's got to sign the certificate that says that the map is technically correct. So it's going to get oversight. And that oversight is something your legal description does not get. Your legal description is going to get done, signed, sealed, notarized, and recorded. And wherever your error is, it's going to be recorded.
What about the date you sign and seal it? Should that be on the document?
Yes. In California, the Board of Registration has a rule, and I don't know if this has the force of law behind it, but it's a rule that wherever you put your seal, within a certain distance, there has to be a date. And something came up where there was no date, and, I know what it was. An engineer was leaving on vacation, and so he took a sheet of paper, and he signed and sealed maybe 4 times on the sheet, or 6 times. But he's got a signature and seal 4 times on a blank sheet of paper. And then if the staff was going to submit a set of plans, they could cut off one of those and tape it to the plans for submittal. And now that didn't happen in our office, but that's the reason why they want a date within, 44.5 centimeters or something from. It gets ridiculous.
Question.
Yes.
I work with deeds all the time, and I never see any seals on the legal descriptions. Why not?
If you're dealing with legal descriptions that are, and we'd have to look at the LS Act and go back to when the law changed that required signatures and seals. When it changed is when the LS Act included language that said that land surveyors have the exclusive right to describe the property of land on the ground. When that language came into being, and a lot of times when you look at the LS Act, below that chapter, article, section, it will say came into being in a date. From that date forward, it's got to be signed and sealed, no matter who prepares it. No matter who. Doesn't make any difference if it's Edison. And Jerry, my partner, has a particular problem with public agencies engineers that won't seal the map, seal the plans. And I'm certain that they were told by the legal department that they don't want their signatures to be legible and they don't want the seal on there because of potential lawsuits. Like, whoa, that doesn't make any sense. They're civil engineers. They're required by law to do this. But in Simi Valley, they don't. All you'll see is a scribble. You won't know what engineer. And it wouldn't make any difference anyway, because you're still going to go to the city engineer or the director of public works as the responsible person for the plans. So I don't know. Lawyers that work for agencies oftentimes defy understanding. But they still are encumbered to keep the city as safe as possible. They're encumbered to tell the staff what to do. So if you see a legal description that's not signed and sealed, and it's within the last, I'd say, almost 20 years, then you've got a complaint. It's entirely possible, if that's the case, that it was not a land surveyor that drafted that legal. Probably wasn't.
I think in residential, when you purchase a home and there's some legal description attached to your deed,
No, if it's the same legal description that came before, like if my house sells, land surveyor does not have to draft the deed. Lot 21 in tract so-and-so doesn't require sign and seal. Yeah, that is exempt because it doesn't take a land surveyor to draft that legal description. They're simply copying the previous one. And that's why somebody in here was talking about, well, a title company will have a legal description of what they're insuring that doesn't fit your survey. Now, we might be talking about a little bit, we might be talking about a lot, but they're insuring a piece of property that's not consistent with what you're surveying. All they're doing is copying what they see to be the last vesting deed.
If you write a meets and bounds legal description, and you sign and seal it, and then that property is sold again with the same description, the seal is left behind and the legal description is perpetuated? Is that how it works? So the next, when you go and get the deed from the latest sale, you go down to the recorder's office and they print that, it's not gonna have the seal on even though it did when it was created?
I'm going to venture a guess that tract homes that are being sold today, the legal description is being made up by the escrow department, and there's no signatures and seals on any of those deeds, not even the first time.
Yeah, but I'm asking about something where there was one the first time.
Or if there was one, and then that was perpetuated, if there was one and it was required at that time, and then it's perpetuated, it's just required again. Now, if there was a signature and seal on the first one, rubber stamping that legal description can be dangerous. If we're talking about a meets and bounds piece of land, I wouldn't want to be the one that is not signing and sealing it. But that's something that the individual has to think about. Land surveyor, if the land surveyor is doing the work of the legal description, then the land surveyor is going to sign and seal it. It's the law. But if it's the escrow department or the real estate office that's doing the legal description, then they are possibly breaking the law. Possibly not. You know, it's not like going 90 miles an hour on the freeway. Who's policing this? I don't know. I don't think anybody's policing it. But if there was a court case where something in the legal description was in question, then maybe the legal description could be defeated because of this. Possibly it might not be able to be defeated. The whole reason for land surveyors being the one to describe the property is because allegedly we best know where to put it. The escrow officer doesn't have a clue where to put the lines. So to create the original legal description, that would be pretty tough for them to do. Title companies have done that. That teacher I had at Pasadena City College, Jim Robinson, he was a licensed land surveyor back in the 50s, and he didn't sign and seal anything, but it was legal descriptions that were created by him for the title company, and he was drafting all the legal descriptions that he was asked to. Yes?
How would you describe a compound curve?
Fence along a tangent curve having a radius of 25 feet. Interior angle of 90 degrees, a length of 3927 to the beginning of a compound curve, having a radial bearing of. Having a radial bearing, I would want to be able to say the radial bearing is either from the radius or to the radius. So I would say having a radial bearing of from the point of compound curve being so much. So now we know it's pointing at the radius point. And most people say, a lot of people say, you're talking radial bearing, it's got to be radial from the radius point to the point. Okay, just make sure it's clear. And there's compound curves, reverse curves are the same way. Along the curve, so many degrees and length to the beginning of a reverse curve, to the beginning of a non-tangent curve, having a radial bearing of so-and-so, to a point of cusp, which is not a compound or reverse curve. Are there any other questions? Yes?
Once had a deed where describing
So how did the owner of the lot that changed modify their ownership to the amended map? How did that happen, do you know? It didn't happen?
The deed still says,
That could be a trouble. If I own lot 4 of a tract and then someone who has no ownership rights over my lot comes in without my permission and modifies where my lot is, I got a civil suit going. They can't do that. And amended map for what reason? Maybe the geometry shown on my map for some logical reason is wrong. And if it's wrong, then I still own lot 4. It's no different than it was before. It's just now more properly described. Yes?
Amended map can't affect right title or interest. I mean, that's why it's prohibited. If you're going to amend a map, it cannot affect right title or interest. Usually, that's not what an amended map is for.
What is it for?
It's to fix errors that are
Yes.
not readily, but you can't affect someone's title with an amended. You can try, and it is illegal. You're probably going to be a civil suit, but it's flat. You can't change a lot once it's been purchased by somebody else and actually affect the acreage they own or anything.
Of course you can't. It's like that map I showed you with that funny-looking curve in there and without the radius point. I asked for radial lines, and the map was deficient, but we can't change anything. Somebody owns that lot. And if the radials, if it works mathematically, and those weren't the prolongation of the south line and the east line to get to the radius point, then too bad. Then they're broken back curves. Those lines are not radial. But the curve itself is not going to change. And if they did an amending map to just show the radial bearings of those lines going to the radius point, that doesn't change the line itself. It just adds enough information so that you can survey it readily.
Now, if the map doesn't mathematically work, you can do an amended map to fix that, right?
Sometimes you don't need an amended map. Sometimes you can do a certificate of correction. A certificate of correction is not to change the map. It's to correct an error in the map. In other words, if it's from block to block and the back line of lots is clearly 600 feet, and you add up all the parts and it comes up 2 feet short, then you can file a certificate of correction showing where the 2 feet was missing and goes. But certificate of corrections are becoming an issue. The county surveyors of several counties and cities are starting to charge some pretty humongous fees for filing certificate of corrections. So now we've decided that whenever we get to the third map check where we're going to Mylar, we'll monument the property, even though the improvements may tear the monuments out. We never did that before. We always wanted to monument after the improvements were put in. And then we'll go out there, and instead of an 1.5-inch iron pipe, it'll be a lead and tack because it's concrete. But now we monument before the map is recorded, so I don't have to pay $600 for a certificate of correction, and my client is gone. I've got to bear the burden myself. Yes?
Yeah, so you monument it, and then it's not approved, so you have to go back and pull all your monuments out?
Yes.
Well, if you do that, you run into a problem where you, if you set the monument before the map is recorded, then once it's recorded, you have construction going on, you can damage all your previously set monumentation, so you will have to reset them.
I don't have to reset them. I've always wanted not to monument until the map is recorded and the construction is done. Because even if it's a house on a custom lot, with all of the construction traffic going on, they're going to destroy the monuments. They humorously say permanent.
Wouldn't allow construction to begin without map being recorded first.
They wouldn't allow construction to begin without what?
Map.
Map? No, the map would be recorded. What I'm saying, because of the cost of a certificate of correction to the maps, is I've changed. I'm now monumenting the lots before the map records, but I'm not monumenting them until the boundary's been approved. I'm not monumenting, then discovering the county surveyor says, oh, by the way, I don't like your lot lines anymore. I'm monumenting them after all I have to do is get the owners to sign the map, and I'm out of here. We're going to record. Now I monument it to make sure that what I'm stating on the map as the monument is exactly what it's going to be. I think it's going to be a pipe. But what happens if I go to set that pipe and there is a drainage ditch there? 3 feet wide, V-ditch, gunite. Well, I'm going to set something in the gunite. I'm not going to drive a pipe through it. So then I would change my map to show what I set in place. I even started setting, this is a quandary for a long time, and on one track, I broke a few caps of a block wall because I monumented after the walls were put in for the lot lines. And I would go back there and find on top of the 6-foot wall, I'd make a mark and etch it, and then I would try to drill a hole for a lead and tack. Well, a lot of these caps were really they're not fragile, they're brittle. And so what I started doing is I just started getting epoxy and putting my tag. Yes.
Can't you just offset it and then note it before you go to Mylar?
Certificate of correction, yes.
Or before the certificate?
The wall's not there yet. Yeah, it's always a chicken and egg thing. Yeah, the wall happens after the map's recorded, and I learned to do this after the '94 earthquake, when all the caps came off with some of the evidence of my sloppy lead and tacks, and one person put the cap back on and they reversed it. The tag was supposed to be over here, and now it was over there. So I ended up just epoxying the tags where they go. And I haven't had anybody tell me that, anybody from the agencies tell me that's not acceptable. They want something more substantial than an epoxied tag. So it sounds like it's pretty substantial to me, but I'm in the wall. And they could say, you could set offsets. Right, I'm not going to pay your $700 fee for a certificate of correction then, because you're directing me what to do. And I don't mind doing it. I'm in the business of putting monuments in. But once the walls are in, I don't know the court case. Once it's a tract now. We're not talking about boondocks. It's the tract, the walls are in. You would assume the walls were surveyed to be constructed. Sometimes they are precisely surveyed, and sometimes they aren't so precise. Normally, on a lot of these speed tracks, the surveyor will come in and put a chisel X out on the curb, a fresh curb, so that the utility people, the people run the sewers and all this stuff, the laterals in, they can see where the lot line goes. They don't see the other end, but they see it out in the street. Now the wall guy can come in and just wing-ding a 90-degree angle, so the back corner, the wall's going to be online, maybe not. Sometimes the developer will want us to go back and set stakes for the rear corners so they can get the walls in the right place. Now, and this is just talk, this is not law, the walls become the monument of the lot lines. I told you where to put the wall. This is my map. You put the wall where I told you to put it, the wall is a monument to the lot line. Now, in court, I've heard a judge say over two people that were fighting over small distances and lot lines that, I didn't hear this, I read it, where that a lot line, where the judge got this, I don't know. A lot line is 3/100 wide.
Really?
You got to be careful when you're in court. I think they get, like, beam me up, Scotty. It's beam me down a solution, Scotty. Yes.
To be noted that in section 66469 of the Subdivision Map Act, there are specific purposes of the certificate of correction.
Yes.
One of the things we found is a lot of times a developer would sell it to another developer. The developer would have the map, the initial developer would have the map recorded. The new guy didn't like the street names, and everybody wanted to do certificate of correction. Can't do a certificate
No.
of correction.
It's got to be for an error.
Right, and that section does state.
Yeah, we did do a certificate of correction for, I forgot what it was now. I hate to even mention it, but it was not an error. We didn't move any lines, but there was something, and we went to the Director of Public Works of LA County, Deputy Director of Public Works of LA County, and asked if a certificate of correction would be okay in this case, because it didn't fit that. And what they said is, are you willing to take the liability? Because there's no liability on us. And I said, I'm willing to take the liability. They said, we'll approve your certificate of correction. So I know that in law things don't look, well, they do look subjective. But all of this stuff, when you're dealing with agencies and you're dealing with people that work for the agencies that have all different levels of experience in land surveying, maybe none. You have, well, in Brown's second edition, I think it is, the preface, he has something that I memorized when I read it. It's not enough to know, you must convince that you know. A large part of our responsibility is to be able to convince our clients that we're competent and know what we're doing, that we're experienced, and to convince the agency that what we're doing is what is intended to be done, and it's correct, and it follows the law. Now, after years of seeing integrity out of you or your staff, the agency will begin to trust you. Jerry, my partner, just we found an error on the grading plan. It had to do with a turning radius for a fast food drive-up. And he put whatever radius he put on the curb, he put on the curb, and the drive aisle, turning 90 degrees, was more than sufficiently wide to handle a pickup truck dually, a king cab. No, certainly no 18-wheeler, but a dually, king cab. But then the owner put the squawk box, this was a Del Taco, put the squawk box near the EC of the short radius curve. So now if you use that full drive line, you'd be 5 or 6 feet away from the squawk box. So people were originally starting to crowd the curb, and they'd go up over the curb. And so the owner of Del Taco asked us, is it designed wrong? So we went out and drove it. We checked our radius, plastic radius things for turning radiuses, and it was not designed wrong. It just didn't work with the squawk box. And we agreed to pay for the correction because we should have asked where the squawk box is going. We're engineers. We're not just drawing sketches for fun. And Jerry asked me if it was okay if that set well with me, and I said, of course it sets well. Now that client has returned to us over and over again to do his fleet of Del Taco restaurants. And now we'll see that our integrity is still intact. We may never get a bill, I don't know. But we may get a bill to replace a radius curb. Now, Jerry did not know where that squawk box was going to go, so his geometry works. Just doesn't work with the box to order your tacos is placed. So that kind of stuff happens all the time. And integrity is something that land surveyors are known to have. And it goes way, way, way back. When I was in the Marine Corps, they sent me to OCS in Quantico, and they sent me to school at Fort Belvoir, which is the Army Corps of Engineering College. And while I was there learning surveying, they had us do a bunch of survey stuff, and then the instructor, the Army instructor for surveying, took us to a place that was kind of cordoned off, and he allowed us all to look at the monument that was there. And he said, look closely at the monument. And it said TJ and then, something J and TJ. And it looked old and rough. And he said, that's a monument set by Thomas Jefferson and his father for Lord Belvoir. This is the Lord Belvoir Mansion before the Declaration of Independence and before, obviously, the Revolution. So, I realized how new the West Coast is. Thomas Jefferson didn't set any monuments out here. So land surveying has been a highly credible field, a profession of integrity for a long, long time. That's why we try to get it right. Any other questions? Well, thank you very much for coming. Oh, by the way, please support your local land surveying organizations. They do great work in California and Nevada. So when you become licensed or you're a student, join up and get involved in them. Thank you.
Thank you.